One of the most important steps in the disciplinary process is the notice of the hearing that must be given to the accused. The notice not only instructs the employee to appear at a disciplinary inquiry, but it is also intended to provide the employee with sufficient information pertaining to the hearing.
Please sit down.
You called me to come and see you. Oh, what's the matter? I am very busy.
Sometimes employers feel that they do not want to provide the accused with information because they're afraid that the employee will construct some false defense if given prior warning. The reality is that in order to comply with the rules of fairness, the employer cannot try to surprise the employee at the hearing. The employee must be provided with sufficient information regarding the allegations against him or her to enable him or her to prepare a proper defense. If you fail to provide sufficient information, the outcome of the hearing may be found to be procedurally unfair. The golden rule is that the employee must be provided with sufficient information to enable him or her to present and prepare his or her defense.
Miss Van der Merwe, there's been a complaint.
What is it this time?
This time is extremely serious and will justify a disciplinary hearing. I called you in to give you a proper notice. Here's the notice.
From information gathered from the complainant as well as the witnesses and, when needed, the accused, the person responsible for charging the employee with misconduct should be able to identify clearly the unacceptable behavior of the accused. You obviously also need to know company policy to be able to identify what rule was contravened. Therefore, after you have talked to everyone concerned and studied your company rules, you now need to formulate a charge. You can use the acronym WWWWH as a good rule of thumb and a sound guideline. This stands for who, what, where, when, and how. Who did what to whom? What exactly was done? When did it happen? Where did it happen? How was it done? You do not need to divulge all the information in the notice, just sufficient information to inform the accused about the allegations. For example, if an employee was pilfering from petty cash, the charge should not simply be limited to theft. You need to give details about what was stolen, when, etc. The typical charge would be as follows: theft of an amount of 100 Rand from petty cash on the 13th of February 2008. In Venus's case, Mr. Lionel would probably formulate the charge as follows: sexual harassment during the period 15 December 2007 to 15 January 2008, when you made unwelcome advances of a sexual nature towards a subordinate, Mr. Willie Weppener. You will observe that it is not necessary to refer to every detail concerning the incident in the notice. This will be done in the hearing proper.